Hi, I'm Aslam and I am a registered attorney, and in today's video we're going to be talking about mental health in the workplace and in relation to sick notes. In other words, we're covering the gray area of sick notes at the workplace and in terms of mental health issues and the use of sick leave. The key question of this video is, should an employee who is on sick leave be expected to stay in bed, or can they participate in recreational activities, for example, by going on a round of golf or fishing if they suffer from a particular mental health issue? To answer this question, we are using a real life CCMA case. The case is UASA on behalf of Adams versus Atlantis Foundries. This is where the CCMA was faced with a similar situation. The facts of this case were as follows. Mr. Adams, who was the employee, was booked off for back pain by his doctor, who also recommended that he consult a neurosurgeon for this issue. However, instead of going to the neurosurgeon, Mr. Adams traveled to Namibia for a fishing trip. When Mr. Adams returned to work, he was charged by the company and dismissed for abusing sick leave. The company told him that the reason for his dismissal was because he used his sick leave as an excuse to go fishing. Mr. Adams then referred an unfair dismissal to the CCMA. At the CCMA, the doctor who treated Mr. Adams was called in as a witness. She testified that when she saw Mr. Adams, his back pain had looked serious, and that is why she issued a medical certificate for him to go and see a neurosurgeon. After both parties had closed their case, the CCMA Commissioner said the following: a medical certificate that has been signed by a doctor and complies with all of the requirements set down by law should be accepted. In other words, if you get a medical certificate which has a date on it, the practice number of the doctor, and signed by the doctor, those are the basic requirements, and if that is presented as evidence, it should be accepted, unless you get to cross-examine the doctor and challenge their witness by bringing your own doctor. Even though the certificate did not allow or excuse Mr. Adams from his decision to go fishing during the period in which he was booked off, the company in that case could not question the doctor's diagnosis. In other words, the company could not prove that Mr. Adams did not have valid back pain because the doctor who treated him came in as a witness to testify. So the fact that Mr. Adams decided to go fishing is irrelevant because he had an illness and a medical certificate to back it up. Therefore, the CCMA found his dismissal to be unfair, and Mr. Adams received his job back and also 6 months of salary as well. What can we take away from this decision? Number one, if an employee is claiming sick leave from work, they must be in possession of a valid sick note. Like I said earlier, the note contains the practice number of the doctor, the date of the illness, and it must be signed by the doctor. In the absence of a valid sick note, there can be no sick leave. Number two, what an employee does during their sick leave is their concern and not necessarily that of the employer. In other words, where there is a valid sick note, then the employer cannot dismiss the employee for any conduct performed during that sick leave, unless the employer wants to challenge the sick note by calling its own doctor. This can be at the disciplinary hearing or at the CCMA. The third key takeaway is, based on this decision, we can also extract that if an employee goes to a mental health specialist, for example, a therapist or a psychologist or a psychiatrist, who then issues a valid sick note for a mental illness, whether that employee goes golfing or fishing, it would be regarded as sick leave because of the valid sick note. However, the company has a right to challenge this evidence either at the disciplinary hearing or the CCMA. If you need help in your situation, you're more than welcome to click the link below and book an appointment with our office. I wish you all the best and good luck.